Good morning. We've already formed a quorum, so let's start the last meeting of the panel on manpower for this session. Item 1 on the agenda, confirmation of minutes of the previous meeting. We've not received any comment on the minutes. If there's no objection, we'll have the minutes confirmed. Please invite the government representatives to come in. Before they come in, since the last meeting, we've received 2 letters, one from Mr. Tang Ka-piu, who proposes the panel to discuss issues relating to the sudden death of employees at work and payment of employees' compensation. The other letter was from Dr. KWOK and Mr. Dennis Kwok, dated the 16th of July, which proposes the panel to discuss the scope of the Employees' Compensation Assistance Scheme. There's another letter that has not yet been formally submitted to this panel. I just received it today and passed it to the Secretariat. Mr. Leung Kwok Hong on youth employment commented on a so-called through-train arrangement formulated by scholars. He asked whether that could also be put on the list of outstanding items for discussion in future. So welcome Secretary for Labour and Welfare and his team. I'd like the administration to respond to those 3 letters first. Before we have formal meetings in the next session, I'd like to have some responses from the administration on those issues. Mr. Leung Kwok Hong's letter is rather complicated in relation to through-train employment. So we welcome the administration today for the discussion of 2 issues. Review of continuous contract requirement under the Employment Ordinance. The administration has already submitted papers to us, paper 1654-01, and there's another paper from the LegCo Secretariat, that is 1654-02. I'd first of all like to invite the administration to brief us on the paper. The administration has a PowerPoint presentation for us. In order that members have more time for asking questions, I'd like the administration to skip the basic information and focus more on the 5 approaches. I think we all know the basic information. So, Secretary, good morning, Mr. Chairman and members. Some members asked the administration to review the employment ordinance to improve the protection for employees for those not under continuous contract. We know that for continuous contract, the employee has to be employed by the same employer for no less than 4 weeks, working 18 weeks per week. We call it the 418 requirement. Having regard to the statistics on employees working short working hours and relevant laws, measures and experience, and having regard to the actual operational arrangements in Hong Kong, we have completed a review on continuous contracts. And then on the 31st of May and the 16th of July this year, the department consulted the LAB. It's a rather complicated issue involving actual operations and problems related to employers and employees. Therefore, the LAB has to study all the issues very carefully and on various possibilities have discussions and seek consensus. For the so-called 418 continuous contracts, the legislative intent was very important. Under a continuous contract, there's a stable relationship between the employer and the employee, and a certain proportion of services and welfare had to be provided to the employee. So stable relationship and basic welfare benefits. A number of technical issues are involved here, so Mr. Chairman today would like to have a PowerPoint presentation. May I defer to our Assistant Director, Mr. Hui Pak-wan, Mr. Charles Ray, for presentation. Assistant Commissioner. Well, let me directly jump to the 5 approaches given the remarks of the chairman. Well, when we consider and review the 418 requirement, what factors have to be considered? Why do we need a review on the 418 requirement? Some employees, just because of the employer's arrangement, cannot reach the 418 threshold and will not be able to enjoy employees' benefits. So is there a need for a review? And secondly, when we are to have a review, we have to consider the legislative intent as mentioned by the Secretary. The original intent for the 418 requirement is to maintain a stable relationship between the employer and the employees and to maintain a certain number of service hours. And on the basis of that assumption, employees have to work a certain number of hours before they can enjoy the benefits, like the number of holidays and rest days. So it's all on that assumption. So we have to look at the legislative intent. Thirdly, if we are to effect changes, we have to consider that after effecting the changes, the requirement has to be reasonable, clear, and easy to understand, and whether or not there is a proper proportion. And there must be a reasonable arrangement between the employer and the employee. The requirements have to be clear and easy to understand. That is on the definition of whether or not the requirement is met. Because apart from civil liability, there's also criminal liability. That is, if an employer thinks that he has satisfied the requirement, or conversely, the employee considers that he has already satisfied the requirement, the employer may fall into the legal trap unknowingly. So the requirements, the statutory requirements must be clear and easy to understand in relation to the statutory benefits. And then the calculation method must be simple. In particular, for employing employees on non-continuous contracts, we may not be talking about big enterprises, but small enterprises or even family enterprises. And elders may employ hourly rated domestic helpers to assist them. So it's rather complicated, and the impact on the employer concerned may be huge. So all changes must be simple and easy to understand. And for those employees being employed under different employers, under non-continuous contracts, we have to consider whether or not he can obtain the same benefits from different employers, and will there be double benefits? And then we have to consider whether the measures will be counterproductive. So let me go into the 5 approaches. All along, ever since we started the review, we've been receiving views from relevant organizations. After collating the views of these organizations, we've considered the pros and cons of various approaches and see whether or not the options are feasible. So we have gauged the feasibility of these approaches. Approach 1, removing the continuous contract requirement. That is, irrespective of the number of hours worked, the number of days worked, or number of days worked in a month and the duration of service, all employees should enjoy the rights and benefits. That's approach 1. But at the same time, if we adopt approach 1, well, let me cite an example. If an employee is employed incessantly, say if renovation works are popular, a contractor employs a worker to do painting for a few days. After the completion of the works, in a few months' time, he'll be employed again at another construction site where there's renovation work to do painting. If we remove the continuous contract requirement, then given that example, in a year, there may be 3 months in which the worker works a few days or 10 odd days. So if we are to remove the requirement altogether? Is it that employee can enjoy the employee's rights and benefits throughout the whole year? That is, in those few months. What about statutory holidays and sick leave and rest days? Should the employer give the benefits to the employee? Well, under the existing EO, if we remove the continuous contract requirement, that would be the calculation. But if we break that up into 3 periods of employment, then even after the removal of the requirement, the employee may not benefit. Well, that's a rather clear-cut example. In other scenarios, there may be other variants. Approach 2. Or in another scenario, if a worker works 4 days in a week, maybe, to serve as leave reserve, or if, say, a security guard is on leave, so somebody else is employed to replace him for just a few days. If we remove the continuous contract requirement, should that employee enjoy the same rights and benefits? That is, 7 days paid annual leave plus 12 days paid statutory holidays. If the person works 48 days a year, should he still be entitled to 19 days of paid leave? So that is the example under approach 1. Well, let us now move to approach 2. Different organizations have proposed a prorating employees' benefits.
So this will be calculated on a prorating basis. Some people say that we can calculate this on the basis of the working hours of the employee and do a pro rata calculation. Well, actually, there are different ways to do it, even if you use a prorating arrangement. The first one here, you can see this is what is done overseas usually, and that is if the working hours are such that it is not a full-time worker, then it will be done with reference to the working hours of a full-time employee, that this will be the denominator, and the working hours worked by the part-timer will be the numerator. This is done in Singapore. And in the majority of other places also, if they go for a prorating arrangement. In Singapore, for example, if you work for the same employer, and if the same employer has a certain number of hours for full-timers, then that will be the denominator. But then if there is not such a comparison, then they will base it on 44 hours. In other words, if it is a part-timer and he works for 10 hours, then it will be 10 over 44, and that is the proportion, which will be about 30-odd%. This is one way to do it. And another way to do it is the denominator will be 18 hours instead of the hours worked by a full-timer. This is also a prorating arrangement. Let us take a look. First, if we follow Singapore or other places, then you will base it on the working hours of a full-time employee. If we put Hong Kong in this situation, if a part-timer works for 18 hours, now he is entitled to 8% of the welfare. But if we use this formula, if the full-time work would equal to 48 hours, and if he works 18 hours, then the welfare he will get will be 18 divided by 48, or 37.5%. In other words, the welfare that he will be entitled to would decrease from 100% at present to 37.5%. This is the first way to do it. If we go for another way, and if the denominator is 18 hours, and do it in a pro rata fashion, and if the part-timer works for 9 hours, then he will be able to get half of the benefits. Now, when we do the calculations under a pro rata arrangement, we can see some problems. For example, if the working hours are not stable, then you will see that if he works for different hours, different number of hours from week to week, then how can we do it in a pro rata way? Say, for example, the calculation for statutory holidays. If we go for the average income during a certain period, and if we go for the prorating arrangement to calculate his benefits, then perhaps when every statutory holiday comes along, he will have to prorate how his entitlement should be calculated, saying it may be 30% or 40%. In other words, whenever the welfare or benefit is due, as you know, we have 12 days statutory holidays every year, so this will be necessary almost every month. In other words, that his holiday entitlement will be calculated on a monthly basis, and the calculations would expectedly be very complicated because every employee will have to have his working hours enumerated, and so that we know what the proportion of the benefit should be. Secondly, the idea of fairness. If a full-timer, for example, works 9 hours a day and 5 days a week, then he would work 20 days a month, and he would have 7 days annual leave and 12 days statutory holidays. In other words, altogether 19 days annually. A part-timer, for example, he also works 9 hours a day, but he only works 1 day a week. Then he will be able to get half of the benefit, as I said. Then every year he will have 9.5 days leave. And when this is juxtaposed against his working days, if he works for 4 days a week, then 9.5 days would equal 2 months' pay. Compared to a full-timer, the benefits that this part-timer is entitled to will be so much greater, because it is 19 days for a full-timer, but he enjoys 9.5 days every year, and that would be equal to 2 months' wages. Now, sickness allowance, sick leave, is also a complicated thing to calculate. The present regulation is that in the first month, you will be able to accrue 2 paid sickness days for each completed month of service, and then 4 paid sickness days for each such month thereafter. If it is done pro rata, and especially if the working hours are not stable, then the number of sickness days accumulated would be different, maybe 1 day for a certain month and 1.5 days for another month. Or the numbers can fluctuate. So in calculating sickness allowance, even if the sickness leave is not taken, you will continue to do the enumeration, and when sick leave is taken, you will again have to do the calculation as to see what proportion of sickness allowance he is entitled to. So actually, when calculations are done, these may be problems. Approach number 3. We have tried to see whether we can change 418 to another way of calculation. Now it's 4 weeks and 18 hours per week. But very often, part-timers may work 18 hours and more most of the time, but in a certain week, he may work less than 18 hours. So there is a view to see whether we should not stipulate 418, but calculate 4 weeks as a whole. In other words, within 4 weeks, as long as you work for 72 hours, you will be able to satisfy the requirements of a continuous working contract. Now, as I have said, in the first 3 weeks, 20 hours, and the 4th week, 12 hours. If we have a 472 formula, then this example would fit the requirements of a continuous contract requirement. But how should we calculate the 4 weeks? This may be complicated. Right now, we go for week after week, and as long as you work 18 hours a week for a continuous 4 weeks, then it is very clear. But if we take 4 weeks, the 4 weeks can roll over. You can count 1, 2, 3, 4, or you can count 2, 3, 4, 5. And things can be different. Let us look at this example. If we look at the blue part, 1, 2, 3, and 4, then this person will not meet the requirement. In the first 4 weeks, only 52 hours, and from the 4th to the 8th week, 62 hours, from the 8th to the 12th weeks, 56 hours, and from the 12th to 16th week, 62 hours. So he will not fit with the formula. But let us say in the 16th week, there is 1 statutory holiday, and if you look at the pink part, then this person will fit the 472 requirement. In other words, the problem with this approach is that somebody may not be regarded as fitting with the requirement all along, but then if you count certain weeks or start counting from a certain week, then he may be entitled. So this may not be clear to employers and employees alike, and employers may not regard the employee to be entitled, but then all of a sudden he starts counting from a certain week and the employee will be eligible, so the employer might have broken the law. And again, from this example, you will see that on certain days or in certain weeks, he works for more hours, and then in certain weeks, fewer hours. And it is easy for him to satisfy the 472 requirement, but then within that period, he may have left the employer altogether for a few weeks. Then would this person still meet the requirement? He may be sick, or he may have taken leave, he may have taken statutory leave, so he is away from the employer for a few weeks. Now, does it mean that the employer should still pay the benefit? Approach 4. We continue to use the 418 formula, but we relax it to 416, for example. In other words, we relax the number of hours worked. And under this approach, as long as there is a continuous 4 weeks, and if every week the employee works for the minimum 16 hours required, then he will be able to enjoy 100% of the benefits, just like a full-timer, and there will be no discount from the benefit. The benefit is that there will be less legislative amendment required, because we all know the legislation very well. Both employers and employees know how the remuneration is done. So if we are going to do it this way, there will be less need to amend the law. And the operation is also familiar. It is easy to understand, it is simple, and nobody will be easily caught by the law. And the benefit for workers will not be affected. In other words, those who are entitled to 100% benefit under EO, after the relaxation, the benefits will still be available. And there would be more part-time workers who will benefit. Approach 5. There has been also the proposal to maintain the status quo, given that the percentage share of continuous contract workers have constantly remained at a high level. So should we just keep the status quo? These are the 5 approaches, and this is what we have summarized after listening to deputations. My briefing ends here. Thank you. Thank you very much. You have heard the administration's briefing. This is time for questions and answers. I'll read out the name list. You must remember we have 2 items, and the other one is standard working hours, and we need to end at 12:45, but judging from the situation now, we may have to extend to 1 p.m. So please make available the time. And we have KWOK Ki, Wong Kok Heng, and then many other members, including myself, and also Albert Ho. There are already 11 members lining up to speak, and maybe we can only have 4 minutes each, and that would already exceed the time assigned for this item. And the 12th one is Mr. Tommy Chung. Members, please make the best use of the time available to you. The clock starts kicking. Dr. K.K. Kwok. Chairman, thank you. We have just received a letter from a concerned group. As you can see, this does not offer enough protection to workers, and I'm quite disappointed that all these 5 approaches are not solving the problem. The biggest problem now is that employers are making use of ways and means to circumvent 418, like supermarkets, hotels. When you have the 418 requirement, in the 4th week, they ask employees to work just 16 hours. And what you are doing now is, apart from approach 1, and approach 2, removing the requirement or using a prorating employment benefits scheme, the others are not useful. The relaxation to 416, that will be worse. Employees will work 15 hours a week. So you are not helping with the situation. What is your bottom line? there are about 100,000 these part-timers, or you call them short-term workers, part-time workers, or non-continuous workers. These are the employees who are mostly exploited by employers. What is your standpoint? You have proposed 5 approaches. I don't know what you're going to do. Many of them are fabricated for the sake of discussion. The Assistant Commissioner talked at length about certain approaches, and in fact you were telling us that there is a no-go with regard to these approaches. Do you want to protect the workers? If you do, then tell us exactly how you're going to help them. Removing the continuous contract requirement and using a prorating arrangement, I think that is the easiest way to do it. And comparatively speaking, there would be less chance for employers to abuse the situation. Do you have a plan to go down that route? Secretary, what is the direction of the administration? Do you have the sincerity to protect workers? Thank you. We are also very concerned about the 418 requirement. That is why the LD did the research and analysis. We have proposed 4 approaches, said the Secretary. And I'm not saying that those are the only options. In fact, we are here to trigger the discussion, so we can look at the issue from different perspectives. Many trade unions, trade associations, and other bodies have been discussing this in the community for a long time, so we are making available these approaches. We have not made up our mind. Not even at the LAB, there is no consensus. It has been discussed twice at the LAB, but then it is complicated, and it is good that now we have the statistics.
Now, with 98,000 people not protected by the 418 requirement, but if you look at the paper, 56,000 part-time workers, among them 40,000 choose to do so. It's not that the employers don't provide them with the benefits, but the employees may have to take care of their family, etc., etc. So we have to conduct analysis into these categories of employees. So there are pros and cons for each and every approach. Secretary, if we remove the 418 requirement on continuous contract requirement, that has always been the request of the labour sector. Secretary, what's your view? Just now, Mr. Hui, in his PowerPoint presentation, mentioned the pros and cons. The biggest difficulty lies with operational details. Have you seen the PowerPoint presentation? Yes. All amendments have to be clear and well mastered by employers and employees. Otherwise, they won't know how to do the calculation. So how should we handle the issue? Clarity and certainty are very important for any changes. I'm very disappointed there's no direction from the administration. Well, they did mention the direction, but the direction is just a stopgap measure for removing the 418 requirement. In the paper, they actually support approach 4. Mr. Wong Kok-heng, Mr. Chairman, the existing employment model is one of a dispersed one. Due to segmentation, we have now a lot of part-time jobs, hourly paid jobs, and casual jobs. The 418 requirements offer no protection to the casual employees, and unscrupulous employers have made use of that requirement to make use of the legal loophole. They try to evade the 418 requirement in exploiting their employees. Under such circumstances, benefits offered to employees by the employers should be pegged to the working hours. Benefits should follow working hours. That will be a simplistic approach, a simple approach, such that this fragmented approach will not take away the benefits of the employees. Otherwise, the fragmented approach will take away the welfare and benefits and conditions of service of the employees. Therefore, before today's meeting, the FTU came to the entrance of the electrical complex to protest and petition to electrical members. In the long run, the 418 requirement should be abolished. For the transitional arrangement, the FTU proposes 4072. We hope that the administration will actively consider that approach. There must be a direction proposed by the administration. There must be an attitude on the part of the administration. Otherwise, it will be actively evading the issue. And in today's protest, the FTU criticizes the government on these approaches. It's just on the eve of the recess of the LAB that the administration has put forth these makeshift approaches. There's a lack of sincerity. Will Secretary please respond to the FTU's suggestions? That is, in the long run, we should abolish the 418 requirement. In the long run, we should have 4072. You mentioned consultation. How long will that take? Secretary, 2 issues, timetable and abolition of the 418 requirement. Mr. Chairman, the paper and my colleague just explained the details. Yes, there are pros and cons for all the approaches. The approach must be practicable and simple and easy to calculate. There is a basis for these approaches. We would like to lay a foundation for consultation. We have due sincerity in consulting the LAB. The administration does not want to hard sell the approaches. There are pros and cons for all approaches. There are merits and demerits here and there. So it's not true that we propose any particular approach. We've sought consensus from the LAB, and after the summer recess, we would like to have a third discussion with the LAB. And Mr. Chairman, this is the first time I come back here to explain to the panel. We just want to let you know our observations on the 418 requirement. Mr. Chairman, what about the fundamental principle of benefits follow working hours? Very simple. Secretary, what's your view? Well, there are operational difficulties as well as merits. We have to resolve the operational difficulties. Otherwise, the approach won't be practicable. That does not mean that we have no direction at all. We'd like to listen to members' views, and then in the LAB we would like to have collective wisdom and come up with some new ideas. Next, Mr. Wong Kok-in. Thank you, Mr. Chairman. The Secretary said that there's a direction, but he failed to give us the direction. In the PowerPoint slide here, we have 4 and 5 clouds. The administration is now putting forth 5 clouds to us, such that electrical members can have some form of a discussion, but that's only empty talk. Approach 1 is our long-term objective, although the administration says that in the short term it's not totally practicable. I think 416 is a so-called lazy person approach. They don't want to do anything, so they just deduct 2 hours from 18 hours. We would like to improve the 418 requirement. It's because we would like to protect the part-time workers, those on non-continuous contracts. But then the administration is doing it in a lazy manner by proposing 416. We must have a fair ratio. Just now, the administration explained that a pro rata approach won't be workable. That's not true. It's just a technical problem. Can we rank or categorize the workers? For those above 18 hours, for 18, one class, below 18, another class. You can propose to the LAB a classified structure. You told us that a pro rata approach won't be workable, but if you classify the various scenarios, you'll be able to do it. Will these clouds represent no sincerity on the part of the administration? Is only putting forth a lazy bone proposal. That is 416. I'll leave some time for the Secretary to respond. Secretary, is this a lazy bone approach? No, of course not. Otherwise, we won't have conducted a review. We've conducted detailed analysis. We would like to be objective and impartial this time. For continuous contracts, right from the very beginning, we said that it's for stability in labor relations. And secondly, there must be a certain duration of service. So the 418 requirement has been in place for so many years. It does have its basis. We would like to satisfy the long-term aspirations of the labor sector, but we have to take care of the employers as well. We did not fabricate these approaches. We discussed with various sectors of the community and came up with these approaches. Well, don't burn my time. Now, you say that is complicated. Can you try to have a class approach or categorized approach? Secretary, is that feasible? Well, we'll take that suggestion back for consideration. Thank you for your invaluable proposal. Next, Mr. Poon Siu-ping. Thank you, Chairman. Of course, just now the Secretary said that in the July meeting of the LAB, they discussed the issue and the discussion was very good. Just last week, I met with the labor side of the LAB. They told me that I had to express their strong dissatisfaction at this meeting because it's only at the last 30 seconds that one of the approaches was discussed. That is the 416 approach. And labor organizations and trade unions did not have time to discuss the details. We've been discussing this for over a decade. Trade unions have always asked for a new system to protect the part-time workers. All along, the 418 requirement has a big loophole. It cannot protect those workers who've worked for the same employer for over a decade but do not enjoy any benefits. Just like the cleansing workers, they cannot receive any severance payment, even though they've worked for the employer for over 10 years. I also received telephone complaints from jockey club part-time workers. They worked for less than 18 hours, and they're not protected by the benefits. Mr. Wong Kok-in mentioned the 5 clouds, which mean ambiguity. Well, prima facie, they look fair and reasonable, but operationally, they're problematic. Just now, some colleagues asked the administration to take the approaches one step further to protect the workers. What about approach 3? Can you improve it? 72 hours in 4 weeks. Then the employees will enjoy all benefits. It's just like the work incentive transport assistance scheme, subsidy scheme. You should draw a simple line. So can the administration consider this transitional arrangement? Besides, they say that they would continue to discuss the approaches and seek consensus. My experience tells me that in the LAB, we, of course, want consensus. But if there's no consensus, what will the government do? What about timing? What about the time frame? What about protection for the employees? Can we have a more reasonable approach? Secretary, a few issues. Strong dissatisfaction that the approach was only discussed during the last 30 seconds of the meeting. And then what's your view about Mr. Poon Siu-ping's suggestion? I'd like to defer to the Commissioner, Chairman of the LAB, for the question about the LAB meeting. I cannot do that on his behalf. And then Mr. Wong Kok-in proposes a so-called class approach. We'll go back and consider that. We would like to have collective wisdom for this complicated issue. if suggestions are practicable, there's no reason we shouldn't consider them. So I'll defer to the Commissioner first. Commissioner? In the LAB, we also submitted 5 approaches to them for discussion. In fact, we had a heated discussion. Sometimes heated remarks were made. We had 2 meetings in the LAB. As the LAB chairman, I'd like to see whether we could discuss individual options which would lead to an easier consensus. We had a long discussion, but as some members said, no consensus was reached, but some suggestions were put forth, and we would like to take that discussion further. I'd like to reiterate that although we don't have a formed position at the moment, from the approaches that you heard from Mr. Hui, for some of the approaches, operationally there are a lot of difficulties. Of course, members will say that technical difficulties can be resolved, but we have to clarify the operational difficulties first. Otherwise, in future, there will be a lot of disputes. For the 416 proposal, we actually have the expression, for example, 416. This is not sophistry. I'm not telling you that in future it will be 417. Oh, it can be 415 or 410.
We have mapped out this direction. Now, if you ask us what scientific basis we have for 416, this is because we have acted according to the principle, and that it is a stable employment relationship, and there should be substantive work done. That is the legislative intent. If the Council now says you do not agree with the legislative intent, then it's a separate thing. Now, according to the original legislative intent, how we can do away with the grey areas as much as possible, how we can improve the legislation, I think that is a direction we can take. Mr. Tang, I have heard the Bureau for long. It seems I have been listening to an employer. 4 out of these 5 approaches are that they are a no-go because they are difficult for the employers. And the last one, 416, which is easy for the employers with its all loopholes, they are hard selling it. And even if it's not hard selling, they are soft selling it to you that this is some good food for you to eat. But as we said, this is a big loophole. The loophole remains. You can work for 3 weeks and then you rest for a week, and then the employer can go so-called scot-free. This is not feasible at all. And therefore, our colleagues have come up with this brilliant idea that 416 employees will be trapped in this plastic cage, so they will drop to the bottom of the sea, and because they will be working 415 instead of 416, the working hours will just be cut further, and it is not going to help things, and there will be no effect resulting from this approach. So 416 is not acceptable at all. And then there are low-skilled workers and lowly educated workers who are cheated by their employers. Even if they work 20 hours a week, they are called part-timers. They don't understand. They are not clear about the 418 requirement. And very often employers would call them part-timers, so they do not have any welfare. And even if I sack you, you're not entitled to any benefits. I'm sure publicity must be stepped up. And then, as we said, 416 is a retrograde step. The FTU has clearly proposed 4072. In fact, 4072 is an improvement upon 418 because there will not be so much restriction. Very often when employers need hands, people would be given a certain number of hours to work in a certain month because they don't want to recruit too many people, and that is why 4072 is an improvement upon 418. Now, of course, 4072 by itself is not sufficient. We are of the view that there must be a pro rata arrangement. The Commissioner quoted extreme and isolated examples. Very often, employers are not going to hire people in those ways. If employers are doing that, they are wrecking their own ship. They are not doing business. You have cited such extreme examples, and it goes to show that you lack the sincerity to amend the law. Last time, it was 2009, 4 years ago, when we discussed the review of the continuous contract improvement. Why have you waited 4 years if you were sincere? This morning we were talking on a radio program when should be the best time to review the continuous contract requirement. Some employers say unemployment is at a low level. Employers place emphasis on their employees, so even if there is no legislative amendment, we won't exploit the workers. But then experience tells us that when the economy was in a bad shape, when employees were exploited, what happened? They will not give you 1 cent more. Now the unemployment rate is low. We have the advantage, we have the flexibility. We must take the opportunity now to amend the law. So don't look for excuses. Don't delay anything. You must, as quickly as possible, review and improve the continuous contract requirement. Can you respond to the question of people having their working hours further cut if you have the 416? We did not hard sell 416. We were reviewing the data. It's just the data. 129,000 people would benefit because they're in that bracket now. 12,900 would be about a quarter of the peace-rated workers. We have these data with us. We did not pluck the figure out of thin air. So we'd like to make available the approaches for discussion. If you say we are not sincere, we will not be preparing these approaches. We must have some basis for discussion so that we can go back and design a workable solution and come back to you. So the entire process is showing a lot of sincerity and is very constructive. Leung Yu-chung, just now I heard the secretary say that he did not hard sell the 416 approach, but Poon Siu Peng has said that the LAB only discussed 416. Just now the commissioner said that at the LAB they concentrated on certain approaches. Which one? Is it 416? Now, if that's the case, then they are saying different things. Who is lying? I hope you will come clean and let us know your direction. Don't employ verbal tricks and tell us that there is actually no direction, but in fact in your heart there is a direction. So come clean. If you are talking about 416, the labor sector will definitely not accept it because it is another trap. It is not very different from 418. Within 416, just now the commissioner, of course, employed verbal tricks. He said, for example, then it should be 415, 414, 412, 413. And this doesn't make a lot of sense. We are talking about a continuous employment contract. And as members have said, employers will call you part-timers. And this is divisive for employees, and the benefits and welfare are totally different. This is not ideal. So we should go for a pro rata arrangement. That is most ideal, and it doesn't complicate things. Just now many members said that there could be a transition of 40-72. In other words, in the end, we will arrive at a pro rata arrangement. I don't know whether you are considering such a transitional arrangement. If today we'd like to remove the entire continuous contract requirement, I don't know why we need a transition. Is it that the administration has clouded the issue by putting forward the 5 approaches? Today, since we have discussed this for so long, why don't we go for an ultimate solution? I think the pro rata arrangement is a strong aspiration within the labor sector. Well, the administration said there are many technical problems. Yes, we understand, and we think they have to be solved. It is not that when we say we want a pro rata arrangement, it will be available very soon. But then there is this major premise, and that is the administration must take up the responsibility. It must play a certain role, or else the problem cannot be resolved. Say, for example, if an employee works for an employer or different employers, how can that be resolved? The administration has a role to play. You perhaps have to help coordinate matters, and the administration may be the big employer and be hiring employees on behalf of employers, so you can calculate how many employers are involved in a certain period and how the pro rata arrangement can kick in. Just now the Commissioner said a good thing, and that is we should concentrate on certain approaches. So I would propose that when you take the issue to the LAB, you should concentrate on removing the 418 concept and go for a pro rata arrangement. And all the so-called difficulties or the technical problems should be put on the table for mutual discussion and resolution. Secretary, can you concentrate on removing the requirement and going for a pro rata arrangement? Chairman, we have written this paper exactly to listen to members' views. We are open and we would like to be interactive with you. We are throwing out these approaches to trigger discussion. Which are the useful ones? Just now the Commissioner said you would like to focus on certain approaches. Which ones? No, the first thing is we put forward 5 approaches. However, if you would still have new views, new perspectives, we're all ears. And then we can go back to the LAB for further discussion. And through numerous and continuous discussion, we should try to forge a consensus, and in the end, the solution preferred must be feasible and practicable. Dr. Peter Cheung-kwok-chi, may I refer to the 5th slide? It is said that statistically speaking, the non-418 number of employees was 141,000 in 2007 and then 148,000 in 2011. Just now the Secretary said that if we change it to 416, over 10,000 people more will benefit. He made it out as if we should be happy, but to us, if there is one without the protection of the EO, we should help this one who does not have the benefit. So, Secretary, please do not feel happy for the 10,000 people, because there are over 100,000 who are trapped in this net where there are no benefits. If I look at these 5 approaches, approach 5 is a non-option, because if you go for it, you don't have to start the discussion. The 3rd and the 4th, they are just patchy improvements. I don't want them. I would tear them up. Therefore, approach 3 would equal to turning a week into a month. So employers can still go for 70 hours or 71 hours. So the problem remains. And then the 4th one, you use 416, or they can go for 415. So my recommendation is, if you go for approach 4, then why don't you go for 401? Once an employee is hired, he is entitled. And of course you will say it is not fair if 401 can enjoy all the benefits and protection, and those who work a full 44-hour week are having the same benefit, then you should go for approach 2. In other words, approach 2 together with approach 3, proportionally giving the benefits, so everybody is being fair. And of course the administration would say, look, approach 2 is fraught with technical problems. Generally, I understand that the bureaucracy will not buckle in the face of difficulties. As long as the direction is correct, it can solve all technical problems. So don't cite technical problems as the barrier. Chairman, approach 1 is, of course, the way to go if we don't want approach 5. So I would say that approach 4, 416, is still fraught with loopholes. So I would say 401 plus prorating employees' benefits. This is my view. I still have some seconds. I'd like to ask the Secretary, after today's discussion, what is your next step? Secretary. Chairman, after today's meeting, we will collate members' views and we'll make use of the summer to work further. At the next meeting of the LAB, we hope we will be able to go back and take the discussion forward. May I use a little time to respond to Cheuk-yan Chi? Now, he mentioned the figure of over 100,000, but let us look at the paper. There were a few tens of thousands of people, actually 98,000. Out of those, 56,000 were part-timers, and they said that if there would be 416, then we estimate that 12,900 would benefit. So a quarter of the 50,000 will benefit. Ms. Ann Chang. Thank you, Chair. Some members propose that we have a pro rata arrangement. I think that is the minimum standard, isn't it? Let me put it this way. We continuously engage someone to work. Let us not talk about working overtime. Sometimes when a worker comes back for 2 hours of overtime work and you only pay him 2 hours salary, that is unfair because he has to come back, he has to travel, he has to pay the traveling expenses, and he spends time on coming back, and if he lives in a remote place, so much worse for him. So I understand that the employers would call this half day's work if it is less than half a day.
And then if it is more than half a day but less than a day, it will count it as 1 day. Many employers employ that practice, which is reasonable. As for the pro rata proposal, it may not be welcomed by the employers. It's also complicated. And then no matter what policies we formulate, we would like to protect the interests of our employees. Is it that the simpler it is, the better? You mentioned 418, 416, 472, blah, blah, blah. Even for the 418 requirement, well, the organizations understand it, but the employees themselves don't know what you're talking about. Even in future, they'll just listen to your calculation. The simpler it is, the better. So you should consider or consult both the employers and the employees by giving them guidelines. So long as it is a continuous contract, if you work less than half a day, half day will be counted. Even if you work 6 hours, that is less than a day, you'll be considered as having worked 1 day. That's simple. It's convenient for the employers and for the working citizens, the employees. They will also find the approach simple and clear. So this is to simplify the requirement. So if they don't work 18 hours, that is less than 18 hours, will you consider that as 18 hours? What are you saying? You said that if they work less than half a day, you count half a day. So what if they work 2 hours? Will you consider them as having worked 4 hours? But that's continuous contract. Yes, continuous contract with a stable labor relation. If an employee works less than 18 hours, can you consider him as having worked 18 hours? We will go back to look into that. It must be simple and easy to understand. If the approach is not understood by employers and employees, there will be difficulties. So we really have to go back and consider the suggestion. Next, Dr. Leung Ka-lau. Thank you, Mr. Chairman. Well, I attended less meetings here, but I think those members with a labor background are rather stupid. Sorry for saying that. They mentioned the pro rata approach, which is stupid. If you are a part-time worker, if you work 18 hours, your wages have been reduced pro rata. If you do it pro rata again, it will be a further reduction. That is, if your full-time pay is, say, $10,000 a month, for a part-timer, you work a quarter, that is $2,500. And then when you calculate the holidays and rest days, you use $2,500 as the basis for calculation. That means for the employer, since the pay of the part-time employee is lower, and then if you do it pro rata again, that is a quarter, the employer will only be paying 1/16. So it shouldn't be pro rata. That means you must use the monthly pay because holidays and rest days are calculated on the basis of a month. That is, for 4/18, your pay is already reduced. So, definitely, we shouldn't adopt the pro rata calculation. Now, what's the principle? When an employer employs a part-time employee, he shouldn't be paying less than in the employment of a full-time employee and no less either. That is, for a full-time employer working 40 hours, if he employs 3 part-timers, then the arrangement, in order to be fair to the employer must not be paying more than employing a full-timer. So even if he employs 3 part-timers, he shouldn't be paying more, and no less either. As for the protection for full-timers and part-timers, well, some protection is offered for all full-timers. And sorry, some protection is for all employees, some only for full-timers. So when we contemplate changes, we don't need to treat all benefits in the same way. Let me cite an example. Rest day and statutory holidays. According to precedents in court, it's ruled that even if you are full-timer, if you work 5 days a week, as you have 2 rest days per week, the 17 statutory holidays will disappear. Previously, we had the Cathay Pacific's litigation with the crew members, and that case was lost. The employer will not need to give more statutory holidays or rest days. So after looking at all the approaches, only approach 1 is all right. That is no differentiation. If you employ an employee for a month and she immediately takes maternity leave, you're in trouble. If an employee works only 1 day and then immediately proceed to maternity leave 4 weeks before and 6 weeks after, so you're only paying her 1.5 days of pay. No problem. So even if you give all the part-timers the benefits of the full-timers, no problem. For paid sick leave, 2 days, if a worker only works 2 days, then of course he cannot be given the paid sick leave. Well, I think we need to listen to Dr. Leung Ka-lau's comments. He said, inter alia, that the monthly pay is already a pro rata calculation, but according to the labor laws, that can be segregated. Technically, there's no problem because severance payment is counted pro rata. Statutorily, as Dr. Leung Ka-lau said, dates can be changed. If the person is not on work on a particular day, there's no paid leave, and then the remaining problems or issues to be handled will be paid maternity leave and sick leave. But annual leave has to be considered. Should it be pro rata, but not for monthly paid employees either? Next, Mr. Tommy Chung. Mr. Chairman, You just said that we should listen to Dr. Leung Ka-lau. Maybe you don't have to listen to me because most of my remarks won't be pleasing to your ears. Well, Mr. Chairman, I think all of us here seem to be treating our employees as fools. 3% of unemployment rate is really low. In the catering business, starting from the 1980s, many people just did not want to work in our business. They want to work in hotels, say they work for 3 or 4 to 5 hours. They don't need to clean the tables, don't need to wait for the end of business on that day, etc., etc. Several hours of wages cannot be considered as the same as the pay for a long-term job for 5 to 6 hours a day with a monthly pay of $10,000. That's not for casual workers. For hourly paid or daily paid jobs, they're different from workers paid on a continuous basis. That is, the long-term workers. For the catering business, there are difficulties for us to employ long-term workers, and some people are willing to work part-time. But now it seems that you are saying that casual workers or part-time workers are being bullied. Well, I'm not an employer now, so I can say this. It seems that all casual workers and part-timers are being exploited. I think these remarks are not reasonable. Many workers can actually have long-term jobs. We see so many advertisements and notices for the recruitment of long-term workers. We don't support a pro rata approach. Why? Because that will add hugely to the administrative costs of employers. Secretary, let me also criticize you. Very often you propose all sorts of options, but very often you don't do assessment. It's not just a question of cost on behalf of the employers. High administrative costs will affect SMEs. How will employers be affected? You have to do an assessment. In your report here, I don't see any comparison. In overseas jurisdictions, what's the percentage of casual workers they have? You mentioned Singapore and Japan. Apparently, you're saying that they fare better than we. They say that no less than 30-odd hours. Is it even for 34 hours they are casual workers? But for us, 18 hours or 18-odd hours, they are already long-term workers. Well, in Hong Kong, relatively speaking, we're very few casual workers. Different for the catering business because we have difficulties in recruiting long-term workers, permanent workers. We'll try to get casual jobs in our industry, a lot of them there. For hotels, for casual workers, look at the Chinese restaurants, look at the pay for casual workers, look at the fast food shops. Look at the wages for permanent workers, and that means full-timers and part-timers and casual workers. You have to have a good business environment for us. But that's the only thing you won't do. Next, Mr. Frederick Fong. Mr. Chairman, I don't know whether the labor sector and the business sector are always in conflict. Well, basically, I agree with my colleagues, Mr. Chung Kok-chi. And let me mention the calculation difficulty. Is there any difficulty in calculation? If you adopt a pro rata basis, it's easier to get consensus. Under the pro rata proposal, a calculation formula should be identified by the administration, and that's to be used by every employer in relation to the working hours, unless you don't record the working hours. All working hours should be recorded, and immediately the system can turn out the results. As for Dr. Leung Ka-lau's proposal, he used monthly calculation. I use hourly calculation. If you use an hourly calculation, Dr. Leung's worries will go. We can handle the difficulties on the part of the workers. As for approach 2, if you're talking about technical difficulties, after this meeting, can the administration set out all the technical difficulties so that we can see whether we can solve the problems by a collective wisdom? As for the business sector, it does not want any change. But even if we don't change, we still have the existing problems. Should we solve the existing problems? And of course, we must look at the labor sector as well as a civilized, open and fair and advanced society. Should we turn a blind eye to the plight of the workers? So we should assist the administration to identify solutions. If we can resolve the technical difficulties, we'll be able to solve the problem. And what about the consultation period? For how long would you like to conduct consultation? What about the supportive and dissenting views? How are you going to handle them? How long will the consultation last? Secretary? Well, we would like to make use of the next few months to do that. Mr. Fong was very correct. Today we're here to listen to your views. We're keeping an open mind. We'd like to improve the present situation. That's the triggering point. Otherwise, what's the use of having a review? After listening to your views, we'll go back and analyze them and go back to the LAB. I believe we'll have to wait till after the summer recess. We'll report to the LAB. We'll set out the whole list of technical difficulties, employers' worries, blah, blah, blah. We'll be more focused. We'll try to come back to you as soon as possible. We'll have a third meeting with the LAB.
When we come back in October, will you be able to list all the issues and problems? Well, October may be a little rushed. I like to do that before the end of the year because the panel will have to be reconstituted. You'll have to elect a chairman. Can we come back by the end of the year to report to you? We will make the best use of our time. We will have our first meeting in October. Please work as quickly as possible. Mr. Manpower? I was listening to the members. Let us get clear why we have the employment ordinance. Some disadvantaged workers should not suffer because of a change in the economic structure or the economic cycle. So these people will not be dealt another blow when they are already in a disadvantaged position. If you start from this perspective, Mr. Tommy Chung said that some people may want to earn more, so they remain casual workers. But then there is a risk. You may not be able to work casually. From that perspective, if we have this benchmark in the employment ordinance, you must have regard for those who are mostly disadvantaged and those who cannot protect themselves. This is the whole meaning of having the 418 requirement. To me, it is very clear and simple. The protect of wages in arrears fund, that is easy to understand. The protection of wages in insolvency fund. Now, if a capitalist does not have the money to hire workers, why should he rely on the PWIF? The concept is that if you go for a class theory, the class of employers should be held responsible. If it is an employer, then you should record clearly the working hours of your employees. And once the worker is sacked or told to go, you can calculate the working hours. This is what Dr. Leung Ka-piu said. This is clear. If you cannot do it, then you can charge a levy by way of business registration. And if the KWIF can do that, why can we not do something similar here? In other words, there should be a fund to make sure that the wages are paid. If wages are not paid by the employer, then people can resort to the fund. Well, if you say, why do you want to do that? It's because it is a class that should be held responsible. And why do you want to dismiss people when the market is buoyant? If you look at the opportunity cost, you ask me to work 2 hours, I still have to travel to the workplace, I have to buy apple daily. It's the same. And the opportunity cost for me will not decrease just because I work 2 hours. Tommy Zhang, when I say I work 2 hours, how can I tell the MTRCL that you charge me a proportional fee only? That doesn't work. So to me, approach 1 is desirable, but you have to have a mechanism. In other words, you do the remuneration, and once benefit is paid, it must be paid in full, as Ms. Anne Chang said. Even if it is not to be paid in full, it must be. And if you ask whether it is fair, well, in the Hong Kong's labor market, it is a zero-sum game. When one industry flourishes, the other industry will wither. The supply of labor is so much. But the problem is that workers cannot eat less just because the market shrinks. I think this is the biggest issue, and it's a simple thing to understand. We are talking about benefits, not wages, mind you. We are just talking about the benefits afforded part-timers under the employment ordinance. I think we should go for that system. Okay, Mr. Frankie Yik. Thank you, Chairman. I'm not a member of the panel. Thank you for allowing me to speak. Last week, I had a gathering with the sector, and they asked me to arrange a meeting with the Bureau Secretary to reflect to the Secretary the difficulties they have in hiring people. I think there is basically full employment. Every sector is saying they cannot hire hands. They would like you to go for importation of labor as soon as possible. This is what my sector told me. Now you're only talking about how the employment conditions can be improved so there is more protection. But SMEs are facing an escalating cost problem. They're already in difficulty. If costs continue to climb, in the end they will just wind up. And actually, SMEs hire the most people in Hong Kong. If you look at the large corporations, they seldom hire part-timers. Mostly they hire full-timers, but SMEs hire part-timers. If we continue to add to their burden, the operating environment would become more difficult and they would wind up, and then the labor market would shrink. This is a problem we have to consider. I remember in the council, a member said, this is the best time for the labor sector. Why don't you allow us to enjoy these good times? But I think you have to look at society as a whole. If SMEs cannot survive, then we are all going to face problems. Secretary, any response? I have heard the remarks. Because of time constraint, I will also state the views of or standpoint of the Labour Party and also the CTU. Mr. Leung Yiu-chung has proposed to move a motion. I rule that it is related to the discussion underway, and I will allow him to move the motion. And if there are no other speakers, we will soon go into the standard working hours item. Now let me state the stance of the Labour Party and also the CTU. Just now the Secretary said something like that he is very open-minded and he is going to listen to our views. But once you lay out these 5 approaches, and in the last 30 seconds of the LAB market, as Mr. Poon Siu Ping said, he would bluff you with everything else, and then they would ask you to look at approach 4. I think approach 4 is the worst. Of course, you can say approach 5 is as bad, but I don't think approach 4 and 5 are different in any way. Maybe approach 4 is even worse than approach 5, possibly. Why do I say that? Because, Secretary, you said 12,900 people are working between 16 hours and 18 hours, and they will be netted in for protection. But then, in fact, those who are in this bracket will suffer because they may be working 17 hours and then they will be cut down to 15 hours and they will be worse off. And then there is a second category that you cannot protect. Last time at the meeting, I said you work 3 hours and stop for 1 week. And as Mr. Tommy Chang said, the F&B sector, they allow you to work for 3 weeks and then you have to stop for a week. It's not that you don't want to continue, but the hotel does not arrange work for you in the 4th week. Mr. Tommy Chang, whether all employers who hire part-timers are exploitative, I dare not say 100%, but there are people who are trying to circumventing 418. These people are exploitative. I'm not saying all those who hire part-timers are exploitative, but then those who are circumventing 418, workers should be able to work for more than 18 hours, but they don't allow you to. And there is this advertisement from CLP Power saying that you will not be able to work for 18 hours every week for a continuous 4 weeks. This is stated openly in the advertisement. So if this is not exploitation, what is? And the 12,900 people will be those who will exactly not be protected. Their hours will be further cut as a result. So, Secretary, when you say more people are going to be protected, I think it's the other way around. You're going to victimize more people. And if you say there will be a lot of technical problems, as Dr. Leung Ka-lau said, there are people who are already treated in a pro rata basis. You don't mention severance payment. If you calculate it on a monthly pay basis, if one works for 4 days a week, and if another works 26 days a month, it is already pro rata because it is 2/3 of the monthly pay. So why don't you go for talk about long service payment and severance pay? And also, if people are paid on a daily rated basis, how should the annual leave be calculated? So you have to discuss all these issues with us. If you are intending to remove 418 and protect these workers, technically speaking, of course you can do it. So it boils down to sincerity. So, Secretary, I want to ask you this. If you do this, in fact, you are going to victimize even more people, at least 12,900. And how do you tackle the problem of people working for 3 weeks and have to stop for the last week? Chairman, I have to say that approach 4 is not our preferred option. We have objectively analyzed all the approaches, and everyone has pros and cons. Even 472 can become 471, and I agree with you, 416 can become 415. So we have to discuss all the approaches, and this is a good opportunity today for us to have a brainstorming session, and we can look at the complicated issues involved. But then the last option must be easy to understand and simple to operate. Okay, thank you for clarifying that you do not have a preferred option. So next time you write a paper, do not picture approach 4 as if it is the easiest option to adopt. And as I said, people can have their hours further cut. But if you look at the paper and how it is written, as if approach 4 is the best. Now I'd like to ask Mr. Leung Yiu-chung to move his motion, and we will not discuss the motion because of the time constraint. Mr. Leung Yiu-chung. Thank you. Chairman, to protect all non-418 employees so that they will enjoy the rights and welfare of the EO, this panel proposes to remove the 418 requirement, and employees who work for 18 hours every week should have 100% protection under the EO, and those who do not work a full 18 hours per week should have pro rata benefits paid to them. Okay, if there are no questions, we'll put the motion to the vote. Those who are members can vote. Those in favor, please wait. 4 in favor. 5. Okay, we will have a division. Hands up. Mr. Tommy Chang, do you want the division bell to be rung? No? Okay, we'll just record the names. I am also in favor. 5. Those against? 2. Abstentions? 1. Okay, you can see the result clearly. Chairman, will you record who are in objection? Yes, it will be minuted. And Mr. Tommy Chang, you asked for a division, so all the names will be recorded. Next item, standard working hours. Secretary, maybe I will tell you in a gist what we seek to do. We'd like to report to you the progress of the committee and its work plan. In order to respond to the concern of society about long working hours, you remember in November we announced the standard working hours report so that we have a firm basis for society to have an in-depth and informed discussion. This is a report of the policy study on SWH. And as you know, in April, the Chief Executive has established the Standard Working Hours Committee, or SWHC, chaired by Mr. Leung Chi-hong. There are 23 other members drawn from the labor and business sectors, academia, the community, and the government. Among the members, 12 are serving members of the Labor Advisory Board, or LAB, who sit on the committee in an ex officio capacity. By virtue of the position on the LAB of the remaining 11 members, as you know, 1 comes from the labor sector and 1 from the business field, and 3 each come from the academia, the community, and the government. The SWHC has an important mission. It should follow up on the government's policy study on standard working hours and conduct further in-depth studies as necessary on the key issues identified therein. And most importantly, to report to the Chief Executive and advise on the working hour situation in Hong Kong, so we know the way forward. Ever since its establishment, the SWHC convened 2 meetings, and in the latest meeting, it endorsed its work plan in order that all sectors will have an in-depth objective discussion on the issue, and so that we can look for an option. For Hong Kong, the SWHC will work in 4 areas. 1, enhancing public understanding. B, collection of relevant information, including working hours statistics and further research into the working hours regimes of other places. And 3, adoption of an evidence-based approach for discussion on the basis of a basket of factors.
Finally, launching public engagement and building community consensus. In order to enhance the basic understanding of the concepts from all sectors of the community, there will be basic promotion education. We'll have information on the website of the SHWC. There will be TV promotional programs which will be aired during the peak hours if possible, and then roving exhibitions. As for collection of information, we agree that we should be data-based in our discussion. As regards the statistics on working hours, we refer to the regular income and working hours survey, which is done annually by the Census and Statistics Department. There will also be dedicated statistical surveys to collect more detailed data on working hours. Now, these data are important because we would like to be data-based before we can have an informed discussion. As for collection of data, working hours on contractual basis, uncompensated working hours, overtime arrangement, working hours arrangement, and fifthly, views on working hour arrangements, and then policy, views on policy. The committee will continue to research into the practices in other jurisdictions. As this is a complicated issue, we time and again said that there will be different impacts on society and the economy. So apart from the surveys I mentioned, the committee also agreed that a basket of factors would be considered to analyze our policy on working hours and their impact on employers, employees, and the overall economy, the job market, the business environment, etc., as well as the long-term sustainability of the economy. So we'll study the impacts on various fronts. As for public engagement and building community consensus, the committee agreed to a 2-stage public engagement exercise. Really, we want engagement on the part of the public. For the first stage, we would like to collect public views on the issue on a macro basis. For the second phase, different options will be put forth for more in-depth public consultation. As for the way forward, the committee, as I said, 2 working groups have been established, one chaired by Mr. Hon TANG Ka-piu, a labour sector leader, and another one led by a business sector leader. They'll invite members of different backgrounds to join the working groups to collect views from all sectors of the community. The working group on working hours consultation will work on the various working hours policy options. And the second working group will consider relevant hour statistics and relevant basket of factors. And before the end of the year, a report will be submitted to the administration. After considering the views of the 2 working groups, a basket of factors and various statistics and analyses, there will be 2 stages of public engagement to collect views. And then we'll see what will be the appropriate policy for Hong Kong and put forth proposals in a particular report for submission to the administration. Mr. Chairman, let me sum up by saying that for this working hour issue, for the labour sector, manpower, supply and demand, business environment, and impact on the labour sector, there will be far-reaching implications. So we have to conduct very careful and in-depth analysis, listen to views of society, and reach consensus in finding a way ahead for Hong Kong. Thank you. 5 members would like to speak. 5 minutes each. Wong Kok-heng, Tommy Cheung, Leung Yu-chung, Kwok Wai-keung, and Poon Siu-ping. I will also join them. So if any member wishes to ask questions, please raise his hand. I believe that will take us up to almost 1 p.m. So please be prepared for the meeting to be extended by 15 minutes. All right? Mr. Wong Kok-heng, please. Thank you, Mr. Chairman. Mr. Chairman, through you, I'd like to ask the administration this. On the basis of the Secretary's introduction just now, when will you contemplate legislation? Earlier we heard that the administration was contemplating 2015-2016 for a decision on whether or not there should be legislation. Now is already mid-2013. You said that the committee would only submit a report by the end of next year. Next year or even next year, you're going to decide whether or not you legislate. Decision on whether or not to legislate only. You're not saying that you will introduce any legislation into this council by then. So would you please elaborate on that? Secondly, according to the Secretary's report just now, a consultancy will be engaged in 2 stages of public consultation. Public consultation is necessary, but you need 2 rounds. And then you will also have 2 rounds of overseas studies. Do you really need 2 rounds of overseas studies? You'll be spending public money, and the time spent will be longer. So, 2 rounds of public consultation with consultancy services and 2 rounds of overseas visits. Can we have some elaboration, Secretary, concerning legislation? At the beginning of the committee, we already openly said that the committee was to explore the direction and policy for working hours. So we don't have a formed position on whether or not legislation is necessary. We'd like to reach consensus, explore issues, and absorb public views before mapping out the way forward. If Mr. Wong is worried about legislation and consensus and whether or not there will be sufficient time, when the committee completes work, if there's consensus that we need legislation, we'll have to do that. Then we don't need to start from scratch because there's already consensus. If we are to legislate, given the consensus, it will only be a drafting issue. This term of the SARG will last till the end of June 2017. I know that the LegCo will have another year to go. Beyond that, we should be able to grasp the time to draft the legislation and introduce it into the LegCo within this term. The committee is working very hard now. They have a meeting once every 2 months. Dr. Leung Chi-hong is very effective. He's been performing very well. The whole workflow is very clear as to what work should be done in what stage. Why 2 rounds of public consultation? For the first round is a more macro one. We're open to public views. For the second round, we work on the specifics. We'll explore options to see whether or not they're feasible. So the second round will be more focused. The first round is broader and more macro. For the second round is more focused. We work on policies. Public money will be spent usefully, so we'll only go to jurisdictions which we think is worthwhile for us to consider. So we'll be very careful with the use of public money for overseas study tours. Mr. Chairman, can the administration be more focused? Well, they should identify certain industries for examination on this working hour issue, and the whole workflow should be shortened. Let me cite an example. In Hong Kong, the media profession, well, many members of the press are here. They don't have standard working hours. They work overtime with no overtime pay. So maybe you can focus on the media profession. Try out overtime pay for overtime work. Or maybe you can have a simulated model for experiment. Will that be helpful? We also have a piece of legislation on Industry Advisory Committee. So you can use that piece of legislation and apply it to certain industries. So have some actual practices and experience first. Secretary, are you willing to do that? Well, we'll bring that back to the committee, the SWHC, for consideration. At this stage, we have to respect the committee. It has already started work. It should continue with its work. It is a clear work process. We should give it room and time to continue with their work. That would be more appropriate. Well, Secretary, you've not answered one of Mr. Wong Kwok Heng's questions. Your reply is not totally correct. You seem to be saying that you still have time for legislation. I think you are somehow misleading the public of Hong Kong. First of all, you did not say anything about timetable. Well, the committee's work will be completed by the end of 2014. In which month of 2015? Early 2015, mid-2015, or end of 2015? A report will be ready for the administration. You have to answer that question of Mr. Wong Kwok Heng's. All right, if your answer is early 2015, then it's better. If you say mid-2015, it's finished for the legislative timetable of Hong Kong, because we know that the LegCo, this term of the LegCo, will finish by July 2016. So if the report is ready by mid-2015, the drafting and introduction of the legislation will only take 1 year. We'll only have 1 year to go. If you are to table that in this council in October 2016, it will be the turn of the CE to finish. From October 2016 to the 30th of June 2017, well, just about a year. So you have to take into account the CE election. So when you answer to Mr. Wong Kwok Heng's question, well, I won't say that you're trying to provide a false answer, but your answer was not completely correct. Well, Mr. Chairman, just now Mr. Wong asked me whether legislation would be possible. I said that it is premature to give an answer now. By the end of next year, the 2 working groups will submit reports to the committee, and the committee would take time to analyze the data, etc., etc. Oh, yes, then when will a report be ready from the committee? Oh, that will take us up to the first quarter of 2016. 2016! Oh, that's what's written now, but of course the chairman of the committee will try to grasp the time well. I'm talking about a hypothetical situation, if there's social consensus, if everybody agrees that that should be the way ahead, since we've collected a lot of views during the consultation exercise, the administration will have received a lot of views. Well, if a certain option is totally acceptable to all, if legislation is necessary, we'll work on that. Yes, we do bear in mind the legislative session of the LegCo will, for this term, it will be up to June 2017, 1 more year. Of course, at this stage, everything is hypothetical only. If that is the way ahead, we'll still have time to do something. Next, Mr. Tommy Cheung. Mr. Chairman, just now you gave a great deal of time to Mr. Wong Kok Heng, including the follow-up questions asked by you. There's no reason for me to ask you to give me 10 extra minutes. If I'm away, a lot of motions may be moved and I won't be here to vote on them. I have to have lunch. I know what you're doing, but you're dragging this on, and if I'm away, motions may be moved. I have to have lunch. Well, I should be here till 12:45. If I'm not here till 1 p.m., I of course have reasons. Well, may I be informed what motions may be moved by which colleagues so that I'll feel comfortable to go and have lunch? Well, there must be discussions on motions. You're spending my time. You're using my time. You cannot take a vote without discussion. All right, those members who are going to move motions, please inform us now. And you can also tell us your position.
There can be motions moved at short notice. Please continue. I have no expectations on this secretary. Same here. I can look at this SWHC. I have very little to say, actually. This SWHC. I don't know whether you want to laugh about it or cry over it. There is only one from the labor sector and one from the business field. The one from the labor sector is Lau Tin Shek, and the other one from the business field, I don't even know who it is, and then you have many people from the academia. 3. Actually, if you get people from the social welfare sector, then it will be very lopsided. On the other hand, if you get people who understand economics, they may be more neutral and unbiased because they know how to read data. I'm not saying social welfare professors do not understand data, but they do have a different philosophy. And then you say the community and the government. What do you mean by the community? Does it mean social welfare sector belongs to the community, but the business sector does not belong to the community? So you can see from the composition that it is lopsided. I'm not saying that the catering sector should be represented, but on the statutory minimum wage committee, the person representing the catering sector has not done anything meaningful. He is in business. He has been there for 2 terms, and Mr. Chairman, once you threaten him, he dares not say anything. And last time, before the statutory minimum wage was announced, people were WhatsApping to the reporters, and news leaked out. And who dares speak up anymore? So when I look at this SWHC, I can see that the membership is lopsided. When you say you want to forge a consensus, then good luck. Now, the paper says, the secretary loves this. Para 5, that you collect relevant information. You talk about a basket of factors, and you will be evidence-based. Come on. You and I know, Chairman, that they can cite the figures they like. When they want to push statutory minimum wage, you look at the government economist's report. The entire department should be ashamed. Mr. Tommy Cheung is just a restaurant operator, and yet the figures he could come up with were more accurate than what the government was able to do. And the government just said, I dared not guesstimate the ripple effect. Well, who was guesstimating? If you could guess that well, then you should go and bet on horses and soccer. It is not a guessing game. It is whether you want to work on it. If you don't like certain figures, you sweep them under the carpet, and then you said your figures would be such that $28 would only affect 0.0 something people. Mr. Chairman, you were of course happy, and then you said that I was cheating people. So the question is, now after a few years, people know whose figures were accurate. I only have 15 seconds, so my advice to you is that you will continue to be a sinner for 1,000 years. You would enjoy the instant applause of the workers. However, you relied on inaccurate and wrong data to come up with a package, and everybody will suffer. The economy will suffer. It is not that the workers will get the benefits in the short term, but if the economy will collapse, everybody will suffer. Secretary, I will give you some time to respond to the issue on figures and data. We will certainly be responsible and careful in putting forward our figures. Today, we have Mr. Chan and Mr. Hu with us. They are compiling figures, and our decision was to balance the interests of everybody, and that it should be advantageous to Hong Kong in the long term. Mr. Ho, as the Secretary said, standard working hours would have an impact on society, employment culture, business environment, etc. There will be an impact on these. The report that we put together provided a lot of figures already, but then if we were really to go in depth into the issue, and if we were to discuss policies, then we would need more comprehensive and even more breakdown in terms of figures in designing the standard working hours. The Secretary is exactly right. We would not be sloppy in our work. The CNSD and our department would provide technical support. We will look at how the research consultant will be gathering figures, and so that the SWHC discussion would be fair and just and objective. Can I have 30 seconds? I never said that the government economist did a sloppy job, but I said that the directions given to him by the Secretary were biased and selective, so that there would be window dressing for the policies. I'm not just talking about the statutory minimum wage, but all other policies in the past. Can I just clarify? We did not provide any figures to the experts. No, you directed, he said you directed the collection of figures. No, we would definitely not issue any directions. Ling Yu Chung, thank you, Chairman. The Neighborhood Workers Association has always said that there should be legislation to provide for standard working hours, because many workers work long hours, and the impact on the family, on caring for their children, it's really great, and they are under huge pressure. In many meetings, I have said to Mr. Matthew Cheung that some workers actually cried in front of me. They said because of long working hours, they had many family problems, and I think you know about it, Chairman. But unfortunately, Mr. Secretary, you were selective in your listening. We wanted you to legislate standard working hours. We did not want you to investigate into setting a system or policy for standard working hours. We asked you to make the legislation, but then your attitude is actually to see whether we should have legislation to regulate standard working hours. You are going against what we were saying. You said there would be consultation, collection of views and analysis, etc. I think you're just employing delaying tactics. And then it may be for the next term of government to make a decision whether they want to go ahead. To respond to what the chairman said, it is only in the first quarter of 2016, and this is just the expectation. It is not a must that you would submit a report to the administration, and we don't know whether you are really going to deliver that. And after 2016, you have to do the analysis and for the government to hold discussions, etc. And if indeed there will be legislation, then the proposal will come back to LegCo for discussion, and then finally we might have the legislation. Does it mean we have to wait till 2017? I even doubt whether we can have something ready in 2017. So it's very simple, Secretary. This so-called flow chart, can you suppress it by half so that we can have local standard working hours legislation to protect grassroots workers? As you all know, you have been with the education department. Many children have to receive or have to have close attention paid to them so that they can be taught in the right way. You also say that family education is important. The parents should also bring up the children personally. But if you don't have the time, how are you going to do it? You also talk about skill enhancement, but people don't have time after work to study. How can we have skills enhanced? And when people work 12, 13 hours, how can that be done? You understand this very well, and now you say you want to look into it. I am really short of words as to what else I can say to you, Secretary. Can you not promise that we will have legislation soonest so that we can have protection for grassroots workers? Can you compress the timetable? You doubted whether the 2016 deadline is for real. Well, yes, it is going to be for real because we set up the SWHC this year, and 4 years down the road, that will be the deadline for the submission of the report. You ask whether the timetable can be compressed. Now, I'm not the chairman, but I can defer to the PS, Ms. Tam, to tell you whether the timetable can be suppressed. Thank you, Chairman. As the Secretary said, at the 2 meetings of the SWHC, there is a labor representative there. In fact, Mr. Leung's view has been fully reflected and discussed. We will set up the 2 working groups, and it is already said that when the 2 working groups go about their work, they have to see how best they can use the time. But we have to have full discussion, and this is a piece of legislation which is regarded as very important for the labor sector, but by the end of 2014, the 2 working groups will be able to submit their reports. The timetable has been fully discussed, and it is already regarded as quite challenging that the 2 working groups have to work flat out before they can submit to that kind of timeline. Now, if the 2 working groups can somehow compress their working time so that they can submit a report before the end of 2014, then the challenge would even be greater. But if the chairman of the 2 working groups think that that is possible, they can certainly give it a try. Mr. KWOK. Thank you, Chairman. As of this moment, the administration has no established stance for legislation. You are employing delaying tactics, and you are helping the business sector. But Mr. Tommy Chang is not happy with the situation because he's saying the administration is not helping it, but it's quite obvious that the administration is on the side of the business sector. But if Tommy Chang is saying that, why don't you come over to our side and help the workers? We are talking about the time frame. Everybody thinks you are dragging your feet. In the entire process, apart from compressing the timetable, can you not have more frequent meetings? Now you have bi-monthly meetings, or 6 over a year. Why can't you have a meeting every 1.5 months, so you have 9 meetings? Actually, most of the work is done by the Labor Department. The members of the SWHC are there to make decisions. If you work harder, if you submit the information faster, then they can work faster. that is possible. Have you thought about this? And I'd like to emphasize another point. Last year in the report, I think a lot of the content has been left out. That is the report of this policy study on SWH, especially with regard to work or trades with long working hours. You have left out the white collars and IT workers, and that was quite mind-boggling because we have heard a totally different story. Their working hours are longer than those 6 sectors you included. I'm talking about hotels and IT workers and also other white-collar workers. I think you should not just rely on the reports from employers. You should look for accurate figures and data yourselves so as to reflect the reality. Or else you are going to invest all this time and you employ the same methodology and you neglect the same trades and work types. You're not going to improve the working environment of these people. And also, if you still stress 2016 as the deadline, as members were saying, you may be dragging a little, postponing a little, then we have to wait for the next term of government for legislation. But we have to state very clearly here, we expect this term of government to legislate on standard working hours, that it should be a work report of the present term of government, not the platform for the next term of government. Secretary, I must reiterate that if you look at the entire work process and the timetable, we are not dragging our feet at all. But you were right. We need to get further figures, like IT and bank staff. Can I ask Nicholas Chan, Assistant Commissioner, to say what kinds of other data we are trying to collect in the next year? Mr. Chan. Yes, very briefly, Chairman. Mr. KWOK was saying that we only got figures from employers. But then in the report, we put together 2 databases. One to get the figures from employers and for paid working hours, and that is according to the annual earnings and hours survey. And also we ask employers whether they pay or do not pay for OT hours, and that is through the household survey. So interviewees will let us know the present situation, and that is how unpaid work is calculated.
As for the unpaid working hours in the report, there will be information on the total working hours. So we'll collect data from both parties. At the same time, we admit that in this amalgamated process, there are deficiencies. For example, classification of industries, how to calculate the working hours for each and every of them, and what about the explanation offered by employers, etc., etc. There are imperfections. So in future, we would like to obtain more accurate data such that we know the actual situation of each and every industry. Yes, short supplement, please. Mr. KWOK mentioned job types with long working hours. He particularly mentioned the IT employees. As Mr. Chan said, IT employees, well, different companies, well, almost all companies have an IT department. The existing database does not provide such detailed breakdowns for each and every industry. So basically, that cannot be done at the moment. That's why we have to employ a study consultant to provide supplementary information on working hours for detailed analysis. Mr. Chairman, in his manifesto, the CE said that he would set up a standard working hours committee. Now, in the annex to the report, it said that the administration will submit a report in 2016. As the Secretary explained, if consensus can be reached and spelled out in the report, well, that's not so certain. There are so many uncertainties related to the next CE election. I'm worried that the effort of these so-called volunteers would be wasted. I very much respect the volunteers, so to speak. of the SWHC, that means its members. But of course, the Secretariat of the committee has its respective work to do as well. So to what extent is preparation work done? And we're given information about the working groups. Previously, we got a study report, 300 pages of it. Can we expedite the process of consultation? Can you expedite your work process? Otherwise, previous efforts will go down the drain. Can all these preparation work be done at the same time so that you don't need to start afresh? And for overseas study tours, you mentioned 2 stages here. What are your preliminary proposals? Can you give us the specifics? If you are to start afresh, the whole exercise will be prolonged. Those 3 issues here. Ask the Commissioner to supplement on the study tours. In fact, they don't go on study tours for the sake of going on study tours. Of course, they have to explain the justifications for the jurisdictions chosen for the studies. Well, the 300-page report, Mr. Poon, provides a very good foundation for the work of the committee. As for the details and breakdowns, we'll defer to the consultancy. Now, the Commissioner will talk about the study tours, and Mr. Chan will supplement on data. Mr. Chairman, to match the study on legislation on standard working hours, the Labour Department has created a principal labour officer post. And then there are 2 teams of our colleagues working on this. One to provide secretariat support to the committee, and another to analyze the data and information. And other labour officer posts have also been provided to support the committee. Well, all the people are there. Mr. Chan, concerning the study tours, we would like to, as far as possible, collect information via the Internet. But sometimes, due to language problems, for example, we're unable to obtain data. So by personally visiting the jurisdictions, we would like to gather more detailed information. As I said, we're only laying a foundation for the committee. So we're doing foundation work only. In future, if the committee wants to look into specific issues like the definition of working hours and so forth, we don't rule out the possibility of further field studies. So you target the 12 economic entities, right? All of them are included except the USA. When we select the jurisdictions, we'll try to explore the social aspects, economic aspects. Of course, we can't have identical economies as Hong Kong. We'll try to obtain more information and see whether the committee needs any more details. Dr. Pokaki. Thank you, Chairman. In fact, last year, the administration already provided us with a figure. At our December meeting last year, we learned that a study had been conducted and a report compiled. The weekly standard hours is 47 hours, 46.6, total 49 and 48 respectively. Be it 40 or 44, those figures are not too far away from what we had imagined. Obviously, Chairman, they are dragging this exercise on. All preparation work has been done. The most important data on working hours have already been obtained. Of course, a lot more details have to be done. Well, this is not the first time the LegCo is legislating. If a bill is to be introduced into the LegCo. A bills committee will be formed, and due consultation will be done as well. We'll consult the employers and the employees, and then finally we will pass the bill. From the time when Dr. Leung Chi-hung was appointed the chairperson of the committee, they're dragging this whole exercise on. In the second and third quarters of this year, they're repeating their work. And for 2014-15, they'll only be engaged in discussion. And most of the discussion issues have already been discussed before. Data, definition, etc. I think by 2016, they'll be providing us with new data, such that if the administration is to legislate in 2016, a further consultation will have to be conducted. Why can't the SWHC from now to the end of next year conduct consultation and enhance its effort on that? If you say that it's only by the first quarter of 2016 that a more concrete proposal can be released, then given the speed now, does it mean that a preliminary option will only be given to us in 2018, plus scrutiny work that will take us to 2020? That means 8 years after C.Y. Leung assumed office, before we can implement the policy. Secretary, first of all, I have to emphasize that we've no intention to drag this on. In the LAB, we have representatives from the employers and the employees. The chairman of the SWHC is working very hard as well. They hold meetings once every 2 months. The secretariat is also under pressure. We have to lay a foundation for the discussion. Back then, they did not have the breakdown figures. If you read paragraph 6 of the paper, you see that previously they did not have the data. So we have to fill in those blanks. Otherwise, how can we work out the, say, uncompensated OT work, etc., etc.? So they need some time. So 2014 is important. They have to grasp the time well for consultation. The first consultation will be more on a macro basis. The second round will be more specific. For example, if there's to be exemption, which industry should be exempted, etc., etc. Both working groups are to submit report in 2014. And then for the whole of 2015, they'll analyze the report and then start writing the final report. No later than the first quarter of 2016, a report will be submitted by the committee because they only have 3 years to work. So Dr. Leung has been working very, very hard. So there must be mutual trust. This is an interactive mechanism. There are scholars, etc., in the committee. We would like to listen to views from all sectors of the community. So we would like the workflow to be smoother. Well, he did not answer my question. A report is coming in 2016. That means the legislation will only come in 2021. Well, Mr. Chairman, he should not continue to use the term dragging on. Well, that's a hypothetical question. If a consensus is reached by the first quarter of 2016 for legislation and a bills committee is set up, if we are to introduce a bill to the LegCo, well, the LegCo term will finish in 2016, but the SARG will finish by the end of June 2017. So, if there's consensus within this term of the SARG, a piece of legislation can be introduced into this council if we have the time and room. So we must map out the way forward. Well, that means you have to complete legislation on standard working hours within 8 months. I think throughout the whole world we'll be the first. Well, only Mr. James Tan and I have not asked questions. Can I be given 10 more minutes? Mr. Leung Kwok-hung also. Mr. Leung Kwok-hung? Oh, that's unimaginable. Well, this is a focus project for the SARG, but they don't have a countdown timetable. Well, that is a lie, the biggest lie amongst lies. Did the liar CE tell you, Secretary, when should we have a piece of legislation? You're a politically accountable official. If an instruction is given to you and you cannot execute that instruction, you have to step down in order to be accountable. If you tell me you don't know when we can have the legislation, that is not appropriate. Well, the popularity rate of CY Leung is very low, but of course he wants to run for another term, so he'll defer this till 2016. The FTU has been cheated by him once already. They said that CY Leung was so good, they dumped all their votes on him. Well, you understand what the Communist Party is all about. In the government, somebody told me that universal retirement protection will not be done, long hair. Well, maybe the popularity rate of CY Leung will drop to 30% or even a negative figure. Then he'll do it. Well, this is so-called image project. You people are fools. You should try to overturn CY Leung until his popularity rate is down to a negative figure. Then he'll immediately tell you that he'll do it immediately. Hong Kong people should not be so foolish. Don't let him drag this on till 2016 and make this a signature project for him. Henry Tang was like that also, Secretary. The COP was set up as a signature project to boost his image and popularity rate. And all of us joined his game. And the COP was disbanded and set up again. Well, this is a question that shouldn't be asked. What legislative objectives do you have? In future, you have a long title for the legislation. The technicalities are no difficulty. What are the major objectives? Uphold social justice, protect the labor sector, the health of the labor sector, destroy uncompensated labor, and collate overtime work.
If you hold on to these four objectives, then of course it is a zero-sum game, right? That gentleman said that we could not get the unpaid working hours, and if you want to ask the labor sector, then you would go for the general household survey. Come on, it is clear that in the labor market, not all the employers, but many of them would regard unpaid overtime work as a cost-cutting factor and also a boost to their competitiveness. Should it be done this way? Should society and government allow this to happen? I have to ask you, what are the ways and means you can use to safeguard social justice? In other words, people worked overtime without pay so that employers were able to make more money and to create so-called prosperity. Can you do something? Can you protect the health of workers? Can you do away with unpaid work? And also, can you compensate for overtime worked? How do you do the calculations? These are the four major objectives. So I find it strange that you ask him what he did. You have to have a theme. So I'm asking you this. What is your legislative objective, if not for the 24 words? Is it a delay? Is it a delay you want to see, or do you just want to build a signature project? Is that your signature project? That is a postponement? Okay, I'll leave you some time. Sorry, one more thing. You must ask Mr. Paul Chan out for a meal, because now you have an easier time because of his scandal. He told me that you should treat him to a meal because he has taken all the blame. Secretary, Mr. Leung Kwok-hong talked about the legislative objective, but we are not there yet. The committee here is to delve into the way forward of standard working hours, including legislation. That is an option. No, Secretary, the administration has got this vision, and then you can have the policy, and then you can have the legislation. This is the political ethics. Are you saying you should do it the other way around? The committee's objective is to investigate into whether there should be legislation. So you do not have a vision. Without a vision, how can you have legislation? It is a game altogether. Michael Tian, in the 2012 MP, on the 18th of December, I asked the Secretary this question. I said, I have heard a discussion in the community on standard working hours, but I have never been able to see why we wanted to have standard working hours. And I heard that there would be two objectives: one, work-life balance; two, exploitation of workers. At that time, I said, if we want to have work-life balance, I think we should go for a maximum working hour level. You're not talking about maximum working hours. You're talking about standard working hours. But the standard can be exceeded. So how come you would have work-life balance? And I said perhaps it was about exploitation of workers and compensation for overtime work or unpaid overtime work. At the time I asked the Secretary, now you have the employment ordinance. Is it that it is not written clearly, so it is not protecting the workers? Why don't you just improve upon the EO so everything would be in black and white? You should be paid so much for working so long, and if there is an OT, what should be done, and do you have the right to refuse to work OT, and if there is OT work, how much pay should be given? And then the Secretary said Mr. Michael Tian has exactly put his finger on the complicated nature of the problem, and this will be the first thing for the future committee to be set up to look into. In other words, the SWHC will first of all look into what you mean by standard working hours and what they are for. But even if you have got the committee, you don't know what standard working hours are for, then you should first of all discuss it. And then on the 5th of May and also the 24th of July, you had two meetings. I'd like to ask the Secretary, what is your decision? Standard working hours, if you continue to investigate into it, what problems do you expect it to resolve? Is there a problem to start with? Or is it that the standard working hours are not there to resolve any problem at all or at all after even two meetings? Secretary, the SWHC is exactly there to investigate into the concern of employers and employees and society with regard to standard working hours and how we should position standard working hours and the way forward. Whether we should legislate for standard working hours so as to achieve that objective. You asked what the standard working hours are for. You have put your finger on the complicated nature of the problem. There are different interpretations. Some people start from occupational safety. Other people, like trade unions, are talking about overtime pay. People are saying different things. So the committee will have to take a comprehensive look at all these issues, including figures and data, and whether there are figures and data supporting a certain approach and what the results or the consequence will be, and whether workers are going to benefit. This is why it is so complicated. Secretary, sorry, I have to say this. With due respect, I have to ask this question. You say you want to do a comprehensive review. When I go to see a doctor, when I say I want a comprehensive review, I mean I need a body check. But then if I don't have any symptoms and I go for a regular body check, then I can understand. If you say the SWHC is doing a body check without any particular objective and just to take a look at working hours in Hong Kong, then it's all right. Then you should not call it the Standard Working Hours Committee. You can call it a Working Hours Review Committee. Or you call it Employer-Employee Relationship Committee. That I can understand. But you say you're not doing a body check. You are telling the doctor that you want to investigate into something, but then you want to do a body check in order to get hold of it. So what is the symptom? I haven't heard you. If you say you want to do a comprehensive research, but the first thing you have to decide on is what is your objective? What is the meaning of that body check? Can you say something on that? As I was saying, is it about unpaid overtime work? That is, overtime work not compensated? Well, basically, the employment contract now offers some protection to employees, right? Secretary, the employment contract does not stipulate that OT must be paid. Right now, the law doesn't stipulate that. It must be for discussion between the employer and employee. Then would you agree that if we legislate to improve upon employment contracts. In other words, you are paid a certain sum and you work certain hours a month. So you can already clarify the issue instead of going for standard working hours. Don't you agree that this is the way to tackle the problem and not just the symptoms of the problem? In fact, Mr. Tian put forward that proposal before. I'm sure the committee would in due course consider your option. Well, but Mr. Tian, your proposal doesn't work because it's impossible for you to legislate to say there should be overtime pay. They can say you work 12 hours, and if I let you go early, then it is a kind of endowment, a graceful endowment, and in the end nobody would be paid overtime work. Well, Chairman, I can't see how standard working hours can resolve the problem. Well, if it is set at 44 and anything over 44 must be paid as overtime work. If you want to have a contract working hours, then there would not be any standard. It can be 12, 14, 16, 18 hours. Chairman, this is exactly the problem. Hong Kong is a capitalist free market. Everything is done with the agreement of the other party. Today, if in my company somebody is happy to work 50 hours and then there is another post where the working hours will just be 44, then these are two different posts. And if a contract has been entered into, then we work according to the contract to pay overtime pay. So how come there would be standard working hours? Standard working hours means it would be for every trade, every sector. Sorry, I shouldn't waste more time on this because this is my time. Later I can have an in-depth discussion with you. Your proposal doesn't work because if, like what you said, all contracts will be set at 12 hours and there will be no overtime pay. People can say 48 hours a week, but then this is not being implemented in many sectors. We will have another discussion. Secretary, you should thank me. Anyway, Secretary, I think I am very disappointed with one thing. It seems you are doing a doctorate thesis. Matthew Cheung, maybe you're an expert in the research into standard working hours. Last year, you issued the report of the policy study on SWH. The last line says that the report serves as a sound and solid basis for stakeholders to have in-depth discussion. Now, however, today, you are not telling us that it is a sound and solid basis, and that is why you are going to build another more sound and solid basis. But Mr. Cheung, knowledge has no limits. If you want to read a doctorate degree, it's for you. You can spend your whole life on a doctorate degree. But you're in government. You cannot devote all the time you need to do research. Mr. Donald Tsang's era has been totally devoted to the research, and then Mr. C.Y. Leung's era is again going to be devoted to research. How can you say this is not delaying tactics? Mr. Leung said in his manifesto that he would promote to legislate on standard working hours. I don't blame you. I blame C.Y. Leung. He said he would promote legislating on standard working hours. Now he is delaying to legislate for standard working hours. This is a total departure from his manifesto. You want to look for figures and research, as I said. Knowledge has no limits. You can spend all the time in the whole wide world to look for figures. If you want to employ delaying tactics, I think you can do so until I'm 80, and you would say the research has to go on. Therefore, if you want to do more research, you are dragging your feet. Secretary, you have no sincerity at all. You said by 2016 we may have a conclusion and we'll still have time. Come on. You cannot make the legislation on standard working hours within 8 months. You all know it is impossible. I don't need you to reply because of the time, but I think I'm so disappointed that the entire SHWC and its timetable are just there to drag your work so that C.Y. Leung will see the end of his term, and then this will be for the next term of government. And there will be more delay, possibly by 2017, but by the time the entire C.Y. Leung's term is meaningless for standard working hours. If we have universal suffrage to return the CE in 2017, if the manifesto says or platform says yes, well, still we don't have legislation. Instead of wasting your time these few years and dragging your feet, well, you're just wasting time. I'm so disappointed that you have no direction, you have no sincerity. Just now, Secretary, you said your stance, that you do not have a stance for legislation. But C.Y. Leung said he would promote legislation on standard working hours. Do you admit that he has already eaten his words? As Chairman, we said many times that his manifesto and his policy address both said that the committee would be looking into the promotion of legislation. Please give some time for the committee to work. The committee will work very seriously, and we will coming back to report on the progress of work. Last, I would call you Dr. Zhang. I think you are a candidate for a doctorate degree. The meeting will adjourn here. Thank you all for coming. Thank you, officials.